all of them cooperating procedurally. Such cooperation does not in any way affect the fairness of a trial, nor the onus on the prosecution to prove its case, nor does it encroach on the rights of the accused. It is a truism, but one which bears repetition, to state that the overriding objectives of a criminal trial, for judges in particular, are, first, the acquittal of the innocent and the conviction of the guilty. Second, dealing with the prosecution and defense fairly. Third, recognizing the rights of the accused, particularly those under Article 67, and any other rights which are germane to a trial. Respecting the interests of witnesses, and last but certainly not least, respecting the interests of victims. In order to achieve efficiency and expedition of a trial, there must be, amongst other matters, first, an early identification of the real issues in the case, and I emphasize that and will return to it later in this status conference. Proper use of agreed fact between parties. Presentation of evidence, whether disputed or not, must take place in the shortest and clearest way. That is particularly important in this trial. Avoidance of unnecessary and lengthy legal arguments. We encourage the participants to cooperate in these goals, and generally between themselves. To give but one example, any requests for disclosure should be discussed between the parties before rulings are sought from the judges. It is incumbent upon the prosecution to give proper reasons if they are going to refuse a request for disclosure. Finally, let me say this. We are delighted to see from the submissions that have already been made that the parties and participants are represented by highly experienced counsel on all sides. And we are heartened, as I say, by the responses which we've received to the scheduling order for this status conference. Those responses show that cooperation exists, and we are optimistic that it will be unnecessary for the trial chamber to enforce compliance with directions made in the exercise of our not inconsiderable powers of case management, which we will employ to achieve efficiency and a fair trial. So having said that, can we move straight away to the various issues in the order in which they were set out? Firstly, obviously, is the start of trial. There appear to be a number of different suggestions. The Office of the Prosecutor says the 30th of November. The defense doesn't want to give any date at all until matters are resolved, such as the accused's fitness. The legal representative of the victims wants beginning of September, and the registry wants January because of interpretation, which I will come back to. Okay. Does anybody want to say anything more? There is actually one matter, Mr. Nichols. Yours is your start date of the end of November is because you say it'll take you until September to complete disclosure. Is that right?
Thank you, Your Honors. You'll find this at paragraphs 3 to 5 of our submissions. Yeah. What I can say is that we've taken a hard look at the I believe, 11 tasks in paragraph 5 that we need to fulfill in a reasonable time before the start of trial. And so in picking the September 30 date, that was not random. It was made in the spirit of efficiency and expedition that you have highlighted. And we believe that is a date that we can meet that will not be easy to meet. It will require us to work hard and efficiently. And then we picked, and of course it's up to your chambers entirely, what we thought was the soonest reasonable start date after that. But we really do think we need that time in order to accomplish all of those different things, different tasks that we need to do. And we think that if we have that time, I mean, I know everybody always argues this, but ultimately the trial will be more efficient because we won't make mistakes and we'll have everything done properly and disclosed properly. Some of that, we have new counsel now, and Mr. Haynes and I have done a trial before, and we know each other. So I do think we'll be able to cooperate. And as you say, we haven't had a chance. We've met and said hello and had a coffee, but we haven't sat down yet to really discuss what can be agreed on, what can be stipulated to. So hopefully that will make it more efficient. But we've calculated in that date of 30th September that the August break doesn't exist, essentially, and that we will keep going through that period. That does not include everybody taken off for 3 weeks. So I can't really add more, and I'm actually going on too long to be efficient, but I rely on our submissions, and we really think that is the time we need.
Yeah, well, okay, Mr. Nichols, I mean, I see that. I mean, you're actually assisted in one sense by the fact there has been a change of counsel, because that obviously causes, well, you're assisted in many senses, I feel, but because of the need for them to get to grips with the case. However, can I emphasize, however, that you really must do things with expedition. We weren't madly impressed by the delay in asking for the matters in your last motion, as you saw. So we'd like you to get on with it. All right, Mr. Haynes.
Could I make just one additional point? I'm sorry, didn't. Just that with this schedule we proposed, other than one case, it would be the fastest from confirmation to trial. I know that doesn't mean that those other cases, that should be the measure, but we were thinking in terms of making this as quickly as we could, and I will, you're correct, of course, about the motion you referred to, and I can address that later. That was our mistake. We own that. There was a miscommunication where we believed that those items were not in custody, but I will address that if you wish later.
Well, no, I think we've given you the warning, so that'll do. Mr. Haynes, is there anything you want to add or say? I appreciate.
Yes, I think what's important for us is that whatever trial date Your Honour fixes upon, you do not, as it were, concertina the gap between that date and the end of disclosure, which has traditionally been no less than 3 months. And so if the prosecution's aspirations are to conclude that and its other tasks by the end of September, then that would mitigate in favour of a start date in the middle of the Christmas vacation, the 30th of December, which would be 3 months later, which has a certain synergy with the other ball in the air, which is the interpretation, which doesn't appear to be ready until January. So that would all tend to suggest that the start of the trial could not be this year. we will be ready for whenever you want it to start. But our anxiety is that that should not be a date which leaves us with perhaps 1 or 2 months after the end of prosecution disclosure. It should be a minimum of 3.
Yeah, but there are pressing reasons which mandate that we really should start this trial as soon as possible, which is basically the health of your lay client. And I appreciate the interpretation, but I'm going to come to that in a moment. But all right, Mr. Haynes, I've got your non-submissions.
For the avoidance of being unclear, if the start date is going to be this year, then Mr. Nichols and his team are going to have to do a little better.
Yes, we'll come to that. Right. Yes, Ms. Masida, your submissions are it should start as soon as possible. I've got that.
Thank you, Madam President. 30 seconds of your time. I don't have to stress the obvious here. Victims would like this trial to start tomorrow. That's as simple as such. However, after the submission of the parties, we had further consultation with our clients. They were amenable to start this trial. 30th of November seems to them at the moment still a reasonable period of time. January 2027, no. For them it's too long. And going to what my land colleague was saying, well, we can start the trial already in November and hear witnesses who can speak English. This will allow to start and continue the trial and solve the issue of interpretation starting in January 2027. Thank you very much.
Yes, okay, Mr. Dubuisson, this is the same problem that arose in Al Rahman, that you don't have interpreters ready as yet to deal with the 2 languages that are apparently going to be spoken by some of the witnesses. However, as we did in Al Rahman, and as Ms. Masida has pointed out, it is possible to start the trial with witnesses who only speak English. And my understanding is that it's not as complicated as finding interpreters as it was in the Al Rahman trial in a language that was only spoken in a small part of Sudan. Because presumably, as court proceedings in the Philippines are all in English, there must be interpreters there, and equally field interpreters who can be trained more speedily, I would have thought, than was possible in the Al Rahman trial.
Mr. Dubuisson, thank you, Madam President. Yes, I take note of what you've just clarified, in addition to what my colleague Ms. Masida just said. Indeed, there are a number of items we need to look at here. Who are we interpreting for specifically? We're interpreting for the witnesses. Today we have a number of witnesses for which we know that they will testify in English. We have been warned that there are some witnesses that will be speaking in 2 other languages of the Philippines. So we need to find, if possible, interpreters who could speak these 2 languages. That's very important for us. To date, we do not have knowledge of who these witnesses are. So, as you have just said, we're going to try and recruit people principally from the field, that is field interpreters, but of course we do have to train them because field interpreters working out in the field work in the consecutive or in whispering chuchotage form, but we are going to be using simultaneous interpretation, so they need to be prepared and trained, not into English, fine, but into the other languages such as Tagalog, those languages that are used in the Philippines. But of course it is important also for the witnesses and for the population that outreach is conducted with regard to the trial that is ongoing in The Hague. So it is important for those out in the Philippines to be able to follow the trial that is ongoing here in The Hague. This is something that we are always attentive to, but it is not our top priority. Our top priority is the language of the accused and the languages of the witnesses. And this is why, with regard to what has just been said, yes, were we to go ahead with the opening statements, if you wanted to have these at the end of November or at the end of the year, yes, indeed, we could find solutions for interpretation for a number of hearing days for those opening statements. But if we're talking about bringing witnesses to testify on a regular basis, then we need to be properly equipped in terms of interpretation booths. And that is why we would like for the trial to commence at a later date. I'm also very aware of the fact that we will need to adapt the hearings according to other criteria that you will determine, yes or no, to do with the accused, and this will enable us to save time. So, for example, if we have shorter hearings, we would maybe be able to improve the training terms and time, but that would only apply to maybe a month or a month and a half in terms of time. So for us, it would be better to start after a 6-month period, that is to say 6 months after today.
Well, as I say, we're going to consider all these matters. We'll give the date that we propose to start at the end of the status conference orally, and we've heard all the submissions. All right. Can we move then, please, to the next item on the agenda, unless there's anything anybody else wants to say? No. And that's the number of witnesses. The prosecution, Mr. Nichols, it's paragraph 6, thinks that you want to, the prosecution intends to call 60 to 70 witnesses, including approximately 31 insider witnesses. Is that right?
Yes, Your Honor, I think...
I'm looking at paragraph 6 of
Yeah.
your submissions.
Yes, I think we can rely on our submissions for this question unless you have any other follow-up.
No, yes, well, only this, while we're on the topic of witnesses, we'll set the number of hours at a later stage, but, and can I say to all parties, we will do the same as I think most trials do now, and that is you'll just be given an overall figure as opposed to timing for every witness. But there is one thing. What emerged as a problem in the last trial of Al-Rahman was the fact that witnesses to the same incident were called months apart, as a result of which discrepancies and things which could have been resolved had they been spotted were not spotted. If we say, as I think we'll have to, given what the registry says, that we're going to start the trial earlier, but they won't have their interpreters ready until the new year, and you deal with them in English, you deal with those who can give evidence in English, rather. What we would all still like is for you to try and call all the witnesses to the same incident consecutively. It makes life very difficult afterwards. Is that something that will? Well, I don't expect you to answer that straight away, but I think it's something we'd like you to consider.
Well, thank you, Your Honor. Yeah, of course we would want to do that. Without rehashing the last trial, it was the interpretation that threw that off because we had to just choose whoever could speak the standard Arabic at the time or in English. I think it will be less of an issue in this case because the case is different in that it's not sort of three big incidents with many witnesses for each of those.
It's a lot of incidents.
It's a lot of little incidents which are fairly discrete, which rely on fewer witnesses per incident. So we will try to do that. If I could just go back to the translation, not to complain, but we did raise this early in order to try to get a head start. We sent a notice on 13 March, I believe, of the languages. My understanding is that nothing can happen until after the confirmation decision, but I just wonder if it can be speeded up because 6 months is a long time, not just for the courtroom presentation, but some of the feedback that we received that my friends representing the victims would know better is that, as Mr. Dubuisson said, there's a lot of interest in this case in the Philippines, and having it not broadcast, I know that's not the main point, and we don't always do that, but it'd be much, much better for the population and the victims and people interested in this case if it could be broadcast in Tagalog or the other languages. So if we start with all English-speaking witnesses, that will require us to jump around a bit, although we will try to keep it as coherent and focused as possible on the particular incidents. But it means at the start of the trial that some people won't be able to follow as well as they should, and that would be a shame. That would be, I think, part of what we try to do here is make this accessible to the population and for the situation in question. So if there's any way to speed that up, that would be excellent.
Yes, well, as I said to Mr. Dubuisson, my understanding is that the court system in the Philippines operates in English. And if there is real interpret, I may say I was quite surprised. I rather was under the impression, and have been told by people who come from the Philippines, that most people there did speak English, but I'm told that's, you all tell me that's wrong. But certainly the court system must therefore have ready and trained simultaneous interpreters.
Yes, Your Honor. I have to say it was not something we had foreseen until we heard after the confirmation hearing and got this feedback. But it's also likely that some of the population from which a lot of the victims in this case were drawn do not speak English. It may be that most people do, but I again defer to my friends, but some of the poorer community where many of the victims are from do not have a good command.
Yes, all right. There's one other thing. I mean, it will be specified in the conduct of proceedings, but I note that a lot of these, the witness evidence is in the form of suspect interviews. Right. Can I make it clear straight away, as I say, it'll appear in the conduct of proceedings, where there are lengthy interviews which wander all over the place in terms of topics and whatever. Before the witness is called, the chamber will expect to have a breakdown in schedule form of the topics which are to be gone through the witness in the order of which they are to be gone through, with a reference in a column to the pages in the actual interview, because, as I say, our experience, certainly my experience from the last trial, was that, as so often happens in such interviews, topics were returned to over and over again. So can I make that clear right away?
Absolutely, Your Honor. We expected that. We've discussed how to do that best, and we plan to do that. I would say that affects, in the most part, 5 witnesses especially. And so we intend to provide very detailed summaries, and we'll put them in the format that the court we will create those schedules, and we will also take care with the summaries for those insiders with lengthy transcripts.
Right. And the last thing is, and I think that's a general comment, it really is incumbent, as I say, in particular because of this case, because of the health of the accused, that the evidence is kept to the minimum possible, and the Chamber would not expect to hear from witnesses all saying the same thing. And I know Mr. Haynes objects to it, and I'll come back to that, but we'd expect as much use of Rule 68.3 and 68.2b, I think it is, as possible.
Yes, we would plan that. That is something I was going to address.
Yeah,
we would like to, the experience of the last trials has seemed to work well. I think the jurisprudence, I won't go into it now to check, is so there is no unfairness whatsoever in using 68.3. It's available to both parties. It makes things more efficient in every way, and we intend to use it. In terms of the length and how much the witnesses need to testify, I think that may be something where we can cut that down. Some of these facts may not be in dispute about a particular murder. We may be able to narrow it to the issues in dispute, which would make the testimony much shorter if the actual fact of this murder or this incident is not in dispute and we're talking about linkage, etc. So we may be able to speed it up.
Yes, well, I'll come back to that when we come to your documentary. Yes, right. Mr. Haynes or Ms. Gibson.
Nothing to add about that.
Right. Ms. Mazzina, anything?
No, Madam President, thank you.
All right. Right, next then, the next topic is, I suppose I may as well deal with it here. Yeah, I'm sorry, before I move on, Mr. Nicholson, I meant to say, the defense did say you should provide at the earliest possible time a provisional witness list. Can I say I agree with that?
We agree too.
Right.
We'll do that 5 months in advance, the provisional witness list. It's already the list from confirmation, obviously.
Yeah.
But we will provide an updated one 5 months in advance, which I think is what was requested.
Right, thank you. Okay, expert witnesses. You seem to be, sorry, Mr. Nicholson, you again then. You seem to be calling an awful lot. On the face of it. I think all we want to say at this stage about it is this, that we're going to propose, I think, that there is a deadline of the 24th of August to provide a list of your experts and their reports, if possible. It would be helpful if, again, as in the Al Rahman trial, defense and prosecution could agree on the nature. And yeah, well, I see Ms. Massina wants to say something in a moment. At the moment, it seems to me it's the defense and prosecution that could agree on the nature of the experts to be called. But I will say this. Firstly, if these are going to be experts that are not on the registry list, you should inform the registry as soon as possible who you want to, because more checks are being done these days on expert witnesses. So it's really important that the registry is given advance notice. Second, if objection is going to be taken by, and this applies to experts called on by both sides, to either the expert and the expertise of the particular expert or the content of the report, again, that must be notified to the trial chamber well in advance of the expert to be called, and if there's going to be any legal argument about it, and particularly involving a voir dire, then that must be notified as early as possible. And I say that applies to both sides. Mr. Haynes, anything you want to say about that at the moment?
Just a couple of things, and I do hope Mr. Nichols will forgive me if we are holding a conversation across the courtroom. It's merely the fact that we haven't had the opportunity to have a lengthy conversation, as he's already alluded to. I just wondered whether the prosecution experts have yet been instructed, how far advanced their reports are, and whether he's confident they could be served by the 30th of September of this year.
Oh, well, we had in line earlier than that, actually.
I'm grateful for that. The note I made was the 30th of September.
I thought I said the 24th of August.
24th of August, yes.
Yeah, I did. Mr. Nichols.
Yes, we have instructed some of the experts. They are underway on their reports. I think we will definitely be able to meet the 24th for the list, which will likely be narrower than what we're looking at here. Part of it depends on some things in the works. As far as the provision of the reports, it's hard for me to say. That may be difficult for some of them, the 24th of August, but we will
Well, I think
follow your orders. As I could say, it's moving. We have instructed the experts. They are working. I need to check, essentially, and I think we could meet that very likely for the most kind of important reports. But there may be a couple. There's a couple things where we're waiting on outside parties, and I leave it there, I think.
Yeah, all right. Yes, Ms. Mercedes, you wanted to say something?
Yes, Your Honor. Actually, it was the same question that my colleague Haynes posed to the prosecution about if the experts were already instructed or not, for one very simple reason. Some of the experts are also interesting for us, so we were thinking of joint instructions. To save time of the court, maybe we will liaise with the prosecution and see what can be done yet. Thank you so much.
Yeah. All right, and I'll say one other thing about experts at this stage. Again, it will appear in the conduct of proceedings, but and that is this: if the side who's not calling the expert intends to show documents during the course of a cross-examination to an expert, they must be provided to the expert in advance of the hearing. As I say, that will appear in the conduct of proceedings. Right. The next item, is anybody want to say anything else on that? Does the registrar, Mr. Dubuisson, want to say anything about experts, other than, obviously?
Mr. Dubuisson, as you indicated, and rightly so, we currently have a vetting system which is much more advanced to circumvent any problems. So it would be worthwhile to be informed of experts ahead of time, so that through these three ways of vetting an individual, we can get from A to B. Thank you.
Next, the use of AVL. The answer, I mean, I don't think I need to say anything else about it. Mr. Haynes, you say it should remain limited and subject to prior judicial authorization. What did you do during COVID?
Stayed at home.
Yes, and did everything on AVL.
Yeah. I mean, I do have one, I hope, helpful observation, and that is, of course, the big difficulty with AVL in this case is the time difference.
Yes.
Ever since the 15th of May, my phone pings regularly from 4 o'clock in the morning onwards, and you can't get anybody after 4 o'clock in the afternoon. And I think it's going to apply both to those who appear on a video screen and those who are brought here, who are going to need, I think, a couple of days of acclimatization to the new time zone they're in. So I think that is going to be a practical problem with AVL in terms of hearing people who are on the other side of the world. Please don't pay too much attention to what appears in the submission document. You will notice its proximity to the date of my assignment.
Yes. Can I say that I agree with, I mean, that is, I was going to raise that anyhow, Mr. Nichols. It's going to be really difficult if they are testifying from the Philippines, because we'll be sitting at something like 6 in the morning, won't we?
We'll have to work that out, Your Honor. In my last job before here, there were sometimes video links that, well, I was present, and it started late at night in the other jurisdiction. We're cognizant of that, and we will only apply for video link when it's impossible to get the person here. So it will be as limited as we can make it, because we would rather they be here. There may be some witnesses who just can't for different reasons.
Yeah. All right. Well, as I say, I don't think there's anything else that needs to be said about that. You don't need judicial authorization. You can, subject to the timings, you can just make that arrangement. Other documentary evidence is the next item. Yes. Now, let me just go through that. You say you're currently, the OTP is currently in the process of determining the overall. Yes, you've got 619 items. Wait a minute, it says paragraph 13. Oh yes, it's it's the speeches. That's right. I want to query with you. 197 speeches seems to me, on the face of it, and without probably not the right word, but it seems to me too much, particularly if they all say the same thing. And I think you need to consider fairly carefully whether you need all 197.
We're definitely not going to intend to play all those in court. We will go through them. These are that will be narrowed. That was, I believe, meant, and Mr. Jeremy may need to help me here in a minute, but that was meant, that's sort of the universe at the moment, and there's sort of, we will make careful selections. We don't intend to introduce, I'm sure, all 197 of those.
Right. Now, the point which is made in the defense submissions is this question of whether documents need to be submitted, go onto the court record through the submission or admission system. I'll let Mr. Haynes address us on this, but the submission system of evidence getting onto the record is now court-wide. I think all trial chambers accept that's the way of doing it. However, as a result of the experiences in our last trial, where there was a whole lot of, in our view, unnecessary and irrelevant evidence that was dumped into the court record through largely the admission of very large documents, even though a witness had only spoken as to one page, or even worse, through the bar table motion, this chamber is going to try and find a fine line between the two systems, which we haven't quite worked out, but will appear in the conduct of proceedings. But one of the things that we have in mind is that where documents are relied upon heavily by either party to the proceedings, and considered to be important, and I take into account the argument mounted on behalf of Mr. Haynes, which has been said on many occasions, that it makes it very difficult to know at the end whether the chamber will find the document to be persuasive or unpersuasive or even admitted at all. And so I think we are going to say, just so that you have advance warning, that where a particular document is said to be important, we are going to say that we will decide on admission or not at that stage when it's presented. But as I say, what I'm anxious to avoid is wholesale, as I say, dumping of documents through the bar table motion. Videos of visits to the country did not seem to help the chamber much in its last case. So that's really all that I want to say at this stage, unless there's anything else. Oh, yes, I'm sorry, there is one other thing. If you're going to want to introduce evidence from open sources, which includes Facebook or any other social media platforms, then we want to know if you're just going to put them in or whether you're going to be calling expert evidence. When I say open source, I mean material that is not directly attributable to a witness or anybody who can speak about it.
Okay, that's understood. We'll look at that.
Yeah.
Thank you.
Yes, Mr. Haynes, anything you want to say?
No, thank you, Your Honour.
Right. Ms. Masida, anything you want to say?
No, thank you.
All right. I take it the registry has no observations on this. All right. Well, Rule 68 we've more or less dealt with. I think we'll leave it to the parties to see what agreement can be reached on 68. As I say, and as Mr. Nichols says, it's quite a 68.3 is quite a good way of getting the evidence in. And yes, and we encourage the parties to discuss that, really. Well, I suppose the only thing, Mr. Nichols, would you be using Rule 68.3 for any of the Article 55 witnesses, or trying to?
Yes, that's possible. I think so.
Yeah. All right. Well, I think we'll see where we get to that. Mr. Haynes, I don't expect any submissions on that at the moment. Agreed facts. Next. Happy to see that everybody is going to talk about this still. The only I mean, we encourage, as I've already said, we really encourage agreed facts. There must be quite a lot in this case because it's a matter of public record what the accused said or did, or in some stages, in some senses. The only question, I see that, Ms. Masida, you submit that the legal representative of victims should have a say on this. The article actually talks about prosecution and defence. I think if you want to, obviously you should be supplied with potential agreed facts, but I think if you want to address us, or if you want to make submissions on it, you'll have to apply for leave.
Thank you, Madam President. I am guided. If can I have 1 minute on this issue?
Yes.
Thank you very much. First of all, two things very briefly. One, it has been court practice to allow victims to notify the chamber if they have or they have not any matter to raise in relation to agreed facts raised by the chamber. And second, in deciding, the chamber shall take into account also the interest of the victims. So on that basis, we submitted already that we should at least give an opportunity to have a say on whether or not the agreed facts agreed by the parties may raise an issue for the victims. It remains, of course, entirely with the parties to discuss. We don't want to be involved in that, but we simply request the notification of the agreed facts just to check whether or not these may have an impact on the interest of the victims and eventually raise that with the chamber. And it's something that can be done in a very quick way. If I can also make this point, if we are notified of the agreed facts, it will take for us not more than a few days to verify whether or not the interests of our clients are indeed concerned. Thank you.
Well, you say that's been the practice. I mean, you quote what you don't actually say which case it was, but I am assuming from the date that it was Lubanga in your footnote 12, at paragraph 10. But what you rightly say is that Rule 69, which deals with that, apart from saying it's the prosecution and the defence, it's for the chamber to decide whether the chamber may consider such an alleged fact as being proven unless the chamber is of the opinion that a more complete presentation is required in the interests of justice, in particular the interests of the victims. So before we even get to that, we have to decide whether if we're satisfied that something is proven, then it's for us to decide before, and it's only if we take the view that we need more information or more complete presentation that the victims come into it.
Well, Your Honor, with all due respect, sometimes the chamber may not be aware of facts or circumstances that the legal representatives are aware of because we maintain the direct contact with the victims. So in this sense, for us, the notification is important because we can confront what the parties have agreed with what the views and concerns of the victims are. And second, going back to the practice of the court, in the Abdullah Rahman case, we notified twice our agreement at the pre-trial stage. Can't remember now the filing. I'm looking behind me. Someone can find that. At pre-trial in the Abdullah Rahman, there were already a list of agreed facts, and if my memory is still good, I hope so. In both cases, there is a filing of the then appointed legal representative notifying the chamber about no opposition of the agreed facts reached by the parties. So it's not an ancient practice of the court. It's a practice that's been prolonged in a number of cases before the court. I leave it to the discretion of the chamber, but I wanted to make the point because particularly in this case, it's important for victims to be fully appraised of what's going on. Victims are very interested in this case. And for them, it has an impact if a fact is already agreed or not agreed. Thank you.
Yes, well, we'll take that, your submissions under consideration. Yes, thank you. Unless there's anything else on that before, yes, Mr. Nichols.
Just, I think in the last trial, I think, agree with Your Honor, the defense and I agree and the prosecution agree what they can, and then the LRV is notified that this agreement has taken place, and we submit them, but I think that's where it ends.
Well, that's my impression, but
Yeah.
I hear what Ms. Maceda said. I just think it would be unfortunate were there to be intervention when facts which have been agreed between the defense and prosecution, who are the parties to this trial, and with the laudable view of increasing the efficiency, I would be reluctant to see it being derailed at any stage. But as I say, we'll return to you on that, Ms. Maceda. All right, finally, before we take the break, languages, I think we've really discussed that, haven't we? Except the only thing that, Mr. Haynes, I was slightly surprised to see was that you wanted interpretation for your lay client, who, as I understand it, as president of the Philippines, ex-president of the Philippines, an ex-lawyer in the Philippines, speaks fluent English.
He won't need interpretation.
Right, thank you. Yes, unless there's anything else on interpretation, I think we've actually discussed that already. Anybody else want to add anything? No. All right. Well, it seems to me, because we're then coming on to disclosure, which will be slightly longer, I think, we'll take the break at this stage and sit again at 11 o'clock.
All right, we will.
is the question of adding new incidents, which the pre-trial chamber left open. And not surprisingly, the defence aren't very happy about that. I think we're going to have to give you a deadline in which, if you want to add new incidents, you're going to have to comply with that deadline, and it's likely to be when we give you the deadline for disclosure.
Your Honor, our date we were going to propose was going to be the end of August, and I can say that we are being conservative in any new incidents we're adding. So it will not be a huge, unmanageable number.
Yeah, that sounds as though you are going to be applying to add new incidents.
Yes, I imagine we will, but I think it will be a few. Some of them are related to existing witnesses where we got more evidence. Some is material that's come in soon, but that fits perfectly within the theory and is just really part of the same case. So, but it will not be a huge number.
Right. Then, Mr. Haynes, anything you want to say? I mean, as I say, we understand your dissatisfaction.
Your Honour, this was going to be the only item on which I made any substantive submissions today, but in the light of Mr. Nichols' comments, perhaps I'll wait to see what is proposed. I'll give you it in outline. We regard the pleading of what are in effect charges as something else, instances or whatever, as a device to get round the fact that what is in fact being done here is extra charges are being added after committal, which of course would require a return to the pre-trial chamber under Article 61(9). This is a very unusually pleaded DCC. I think if you look back at Abdel Rahman, you'll see that what in that case would have been a topical heading by geographical location or similar, here has been pleaded as a count which in old money I think you and I would have regarded as duplicitous because it alleges 19 murders as a single charge, and of course thereby deprives the trial chamber of delivering different verdicts on each of the underlying acts. But as I've said, I'll keep my powder dry for today. We're not going to be silly. Our real concern is what the parameters of this trial are. If we are to investigate, say, even 50 plus episodes, then that's manageable. But if the suggestion is that we are, in effect, in a sort of public inquiry here, which spans 300,000 square kilometres and a nation of 120 million people over 7.5 years, then this trial really is going to get out of hand and our investigations will be impossible.
Yeah, well, Mr. Haynes, that's fine. I mean, until such time as we see what the prosecution is proposing. I mean, your problem is that the pre-trial chamber specifically left it open, and I suppose it's if you go back to the old days, it's like pleading a fraud with all sorts of different instances which are examples of the fraud.
Yes.
But anyhow, I'm sure that Mr. Nichols has heard what you're saying, and Mr. Nichols is fully aware that the trial chamber has every intention of this trial proceeding expeditiously. So,
Thank you. Yeah, I'll speak to my friend when we have a chance, and I think I'll be able to put his mind at rest.
yeah. Yes. Thank you very much. Again, Mr. Masida, I don't think there's anything that affects you on that. Yes, or the registry. So, on the question of outstanding disclosure, I think both of you are agreed, and can we emphasise that the trial chamber thinks is very sensible. Disclosure will go on a rolling basis as before, and the same deadline effectively is going to apply to all of this, these matters of disclosure and the like. Yes, and if there's to be any request for delayed disclosure, could you send that, could you file a motion to that effect as soon as possible, please, Mr. Nichols? And you've got to show good cause, as you might expect.
Yes, Your Honor.
Right. All right. Well, having said disclosure was like to take more time, Mr. Haynes having kept his powder dry, we can move on to transcription. Any updates on what you said at paragraph 28, Mr. Nichols? Or was it more or less the same?
It's no update, Your Honor.
All right. Yes, and we'll, as I say, produce the same deadline. Right, witness protection. As I understand it, from paragraph 31, Mr. Nichols, you will work towards disclosing the identity of all witnesses by the end of September 2026. Does that mean also any new witnesses that you're intending to propose?
Yes, Your Honor.
All right. I mean, if you want to give any updates, it ought to be, I suppose, in private session.
Yeah, no, I don't think any updates. It's just, as you said just a moment ago, if we need to apply for delayed disclosure of an identity, we'll do that as soon as possible.
All right, and if there are going to be any discussions about that or anything which needs to be ex parte, then we'll deal with that at the next status conference, or anything that needs to go into private session. And yes, protective measures, obviously, as soon as possible. Actually, I think, nonetheless, we'll just briefly go into private session for a moment. of any defences in accordance with there are none, is that right? Conduct of proceedings will deal with Mr. Nichols, the OTP says it would happen to be the 30th of November. Yeah. Trial chamber shall confer with the parties and adopt such procedures as are necessary the following issues. And two of the issues that are germane to this point are H, the issues that the parties propose to raise during the course of the trial, and P, the defences, if any, to be advanced by the accused. The trial chamber is of the opinion that it would assist the fair and expeditious conduct of this trial, which I referred to in my opening remarks this morning, for the defence to provide a document before the start of trial, which sets out, first, the matters which the prosecution are proposing to lead in evidence with which the defence takes issue. Second, sets out in general terms the nature of your defence, and that means going further than saying these are not crimes against humanity, Mr. Haynes. We do not expect you to provide the complete detail of the defence at that stage. The provision of this document does not preclude you from raising further issues at a later stage if those become evident to you in the course of investigations, nor does it encroach upon your right to file a pretrial brief. And we therefore propose to order you to provide this document 1 month before the start of trial. So, is there anything you want to say about that?
No, we'll comply with that, of course.
Thank you very much. Yes. And then I think, unless there's anything... Oh, I'm sorry, Ms. Massidi, yes, as far as the victims are concerned, you may file a brief. I assume it will be before you, if you decide to call any evidence as to the views and concerns of the victims.
Yes, Madam President, our position at the moment, we are still finalizing our internal discussions, but our position will be to file the pre-trial brief before the start of the trial. As it was in the Abdulrahman case, again, if my recollection is okay this morning, I believe the prosecution filed 1 month after the LRV filed and then the defense filed in the Abdulrahman case. We are, of course, open at any order of the chamber. We will comply. No problem at all. Thank you.
That's fine. I honestly can't remember. I rather thought that in the Ar-Rahman case that the defense filed before they started to call their evidence, but I may be wrong.
I think, Your Honor, there was a choice for the opening statements. If there was a choice of doing the opening statements for the LRV as well, at the start of the trial, or once we will request to submit evidence, if ever we will request that. I think this was the option.
Yeah. Well, I'll check that. I'll check that over. We're going to have a break before we deliver various oral rulings, and we'll check what that was.
Thank you very much.
Yeah. Pre-trial motions. Yes. The Office of the Prosecutor says 30th of October if the start date is the 30th of November. The defence effectively going back to the question of the start date is I'm going to come on to that separately, I think, but a determination of the accused's fitness to stand trial. Yep. I mean, do you want to say anything about deadline for the filing of motions?
No, we'll comply with whatever order you make in that regard, Your Honour.
Ms. Masidi, you're the same, are you?
Same as well, Your Honour.
Right, thank you. Okay, well that brings us on to opening statements, which we've more or less had a discussion of it. We'll come back with the hours at that stage. On the question of victims' participation, yes, I think what we'll say there that the defence invites the deadline for applications by the victims to participate 30th of September 2026, and CORV request until the end of the COR case, or at least until the close of the prosecution's evidence. I think we're going to go, as we did in the Al Rahman case, say that it's going to be the end of the prosecution's evidence, unless there's any objection to that. Mr. Haynes.
Perhaps a slightly different observation, and that is going back to the point that's still in the air, as it were, as to the parameters of the case as a whole. If this case does involve 49 incidents and 73 deceased, then even allowing for multiple dependents, one would expect the number of participating victims to be in the low hundreds and not the high thousands. And Ms. Gibson and I have had recent experience of the harm that can be done in admitting thousands of victims to participate in proceedings, only for them to find out in the reparations phase that none of them fall within the ambit of the convictions, if any. So I would hope there'd be some careful analysis on the part of those assessing these applications as to whether they fall within the ambit of this indictment as it is currently pleaded, because it's doing victims no favours to allow thousands and thousands of them to believe that they might receive compensation at the end of the day, when that is unlikely even at this stage. The other observation I would make, which comes from my experience in the Bemba case, is that multiple applications throughout the trial process overwhelm the defence, because we have to look at them and nobody else does, and we have to review them at a time when we're cross-examining other witnesses or presenting our own case. And so I would invite you to consider whether or not that, given the potentially relatively low number of victims who do qualify to participate in this case, whether that shouldn't be done before the trial starts.
Right. Well, Ms. Masidi, yes, first of all, and then I think I'll go to the registry.
Thank you, Madam President. Just very briefly, I wanted to recall that at the request of a pretrial chamber, the prosecution indicated that the number of incidents are only indicative of victimizations, and they are not to be considered an exhaustive list of potential victims. This was confirmed by the decision confirming the charges, and therefore I suspect, and these are our assumptions at the moment, that a high number of victims will manifest themselves for trial. And our assessment is done by, of course, having contact with the affected communities. And we can already indicate that a number of victims already enter in contact with us to manifest their willingness to participate in this trial. Second, Your Honor, if the prosecution is going to add new incidents, then at that point in time, victims will need time, in any case, to continue to manifest themselves for trial. So the end of a prosecution case seems to us, as in previous cases, the most reasonable deadline in order to effectively grant the right of victims to participate in this trial. Thank you.
Right. Does the registry have any observations to make on this?
Mr. Dubuisson, we are completely in agreement with this position, which is also yours. I could also ask Mr. Ambach to give you extra information if you so require.
The only point I would have to add to what the legal representative has already submitted, which is also part of what we submitted in our own filing as to the scope of the case, is that the burden on the defense and the prosecutor in terms of the analysis of applications would be minimal if one were to follow the ABC approach that we have proposed to continue from pre-trial into trial, whereby only the unclear forms would come to the analysis of the parties and the final decision by the chamber, which, as we also submit, would be minimized to the later stages of trial, which was obviously also a part motivating our suggestion that one were to continue the possibility of victims to come forward until the end of the evidence hearing. Thank you.
Right. Well, we certainly approve the ABC approach. I mean, I think that's our standard through all trial chambers. So, really, the submission of the registry and the victims representative, rather, is it should be the end of trial. Defense say cut-off date, and prosecution didn't say anything really, I suppose, on this. All right, it's one of the ones we'll give a ruling on when we've dealt with all other matters. Witness preparation. A lot of this will be dealt with, as I say, in the conduct of proceedings document, which we'll issue as soon as practicable. Yes, the prosecution can have the same witness preparation protocol as it had in Abdul Rahman. There is, and the adoption of the protocol is used for preparation, familiarization, and vulnerability will apply as well. However, there's one matter I want to mention because of what happened in the Al Rahman trial. The proceedings were delayed one morning because the witness who was due to appear that morning had requested during the 24-hour, if I can put it, quarantine period before they give evidence to speak to the office of the prosecutor because he had remembered something or wanted to change something, and that request was not transmitted until the morning that the witness was due to testify, when he did give new information, and as a result there was a delay. Accordingly, if that is what a witness requests, and it matters not whether it's a defense witness or a prosecution witness or somebody called by the CLRV, then notwithstanding the 24-hour quarantine period, that request should be immediately transmitted to the party calling the witness, and unless there is good reason why they should not speak to the witness, they should be allowed to speak to the witness and obviously make a note and provide it to the non-calling party. But it was a lengthy delay which was unnecessary and in my view need not be repeated. Right. Unless there's anything else on any of that, it's standard. Right, the sitting schedule for trial. Now this does bring me on to the fitness of the accused, Mr. Haynes. As you rightly pointed out, and you filed a motion to that effect, the finding of fitness related to the confirmation proceedings, and the Chamber is obliged to make a separate finding on that issue. And you very sensibly propose that the three gentlemen who examined him for the purposes of the confirmation proceedings should be re-instructed to re-examine him. And we propose to make that order hopefully either today or tomorrow. You also ask that they be made available for questioning. I think we will, I mean, the first thing to say, it makes sense because these three experts examined him for the purposes of the confirmation proceedings. Therefore, they don't have to go back over all the background that was taken on the last occasion. As regards having them brought for any questioning by the parties, I rather think we'll wait and see what the reports say before we make such a decision.
I agree, Your Honour.
Thank you very much. In that case, as I say, we'll. I only hope that they can carry out the assessment with some speed. So therefore, at the moment, it's a bit difficult to set a schedule for trial until we've had an up-to-date report. But it seems to be that because of his age and potentially medical problems, there will have to be a day off, and I see the suggestion is that it's in the middle of the week. But as I say, I'm reluctant at this stage, without further reports and without an assessment made by the experts of to set a schedule. So I propose to adjourn that until we find out what the situation is, unless anybody thinks differently. No, I'm taking silence as assent. The representatives of the victims finally want a secure and private remote room. I think you have to take that up with the registry. I mean, if they can arrange that, that's fine by the trial chamber. It's not really a matter for us. The final matter was the suggestion by the prosecution of an alternate judge. I don't think that really is necessary. All right. Are there any other matters? We're going to adjourn, and I suppose we could try and do it before, just to go through the rulings we're going to make. Just give me a moment. I'm reminded, Mr. Nichols, I should have asked you if you've got anything to say about the experts examining him.
And we would have, but you've made your decision.
It didn't occur to me that you were going to object, but
We had some things, no, we accept that. The one point I would make very briefly is we would hope that your honors would instruct the experts. We would not agree with the defense's proposed letter of instruction
Oh, I
in
see.
its entirety.
Yeah, I forgot about that.
Some
yeah.
of the points we feel we would take issue with, but so we think your honors should do the instruction according to the test from Strugar and Hodzic and Bagbo. And so appreciate the trying to save time and be helpful, but we would not agree with this letter going as is.
Yes, all right. Right. And in fact, quite rightly, of course, the people are going to be concerned with the registry. Is there anything you want to say on that, Mr. Dubuisson?
Mr. Dubuisson. No, I believe that to find experts that are immediately available and who know the interested party, I think that this is the best solution. And today, I do not believe that they will deviate very much from the previous recommendations.
To see what they say, rather than anticipating it. Okay. Yes, Mr. Haynes. All right. So the prosecution doesn't much like your letter, so I think the chambers will write.
We were only trying to be helpful.
Yes, thank you. All right. Yes, I'm sorry, I forgot about that. All right. What we're going to do is adjourn until 2 o'clock, just so that we can take time to consider the various matters being raised. Before I do that, however, can I just say one last thing, which really has no bearing or impact on the case or how it will be conducted, but for the purposes of transparency, knowing that there is public interest in this case, I should say, and this is myself speaking rather than on behalf of my fellow judges, it's probably well known that the world and the pool of international criminal law lawyers and judges is a limited one, and it is therefore probable that judges and counsel will have met before this case or during other cases, or possibly at conferences or even social events. In this case, as it so happens, I know counsel on both sides. As far as Mr. Nichols is concerned, apart from the fact that both he and Mr. Jeremy appeared as prosecution counsel in the case of Al-Rahman, Mr. Nichols and I worked together now over 20 years ago as counsel at ICTY. Mr. Haynes and Ms. Gibson, Mr. Haynes I've known, though not in a professional way in the same way as Ms. Nichols, for almost as long, and Ms. Gibson for less time. We have met and, as I say, are likely, almost certainly, to meet again at seminars and social functions. Although it's not possible to predict that with any certainty, the one thing it is possible to say with certainty, there will be no discussion whatsoever of this case between parties and the judges at any such functions, and as I said already, it has no impact on the way that this case will be conducted or any rulings that may be made by this chamber in respect of submissions made by all sides. So thank you very much, and we'll adjourn until 2 o'clock.
All right, we will.
question of household forms as opposed to individual ones, as well as victims in pre-trial. Now, we had in mind, and I just want to hear at this stage if there's any objection to make various orders. Really, for the VPRS to file a report including the possibility of having a mapping report and household forms. The main mapping report to be filed 30 days after the Article 74 judgment. I see Mr. Ambach indicating assent, I think is the polite way of putting it.
Assent, no.
And next we were going to authorize the use of household forms in addition to individual application forms, unless there's an objection. If there isn't, then we'll authorize it. If there's an objection, we're not going to make a ruling, and you can make submissions from my side.
Thank you, Madam President. As far as we are concerned, we would prefer to maintain the individual. As far as we are concerned, we would prefer to maintain the individual form and the household form, so that victims can choose which one, because on occasion, some victims would like not to complete a household form because some members of their family may not be aware of what happened.
Right.
So we would prefer to maintain both options. Thank you very much.
Right. Well, is there any objection to this? If no, I see Mr. Haynes shaking his head. I see Mr. Nichols shaking his head. Right. Then we will authorize the use of both forms, Ms. Masida. And finally, we were going to order that the victims who participated in the pre-trial proceedings are authorized to continue participating in the trial proceedings. Any objection to that? No. Okay, well then we make that order as well. We didn't mention, but I'm going to mention now this, that pursuant to Regulation 37 of the regulations of the court, we're going to limit parties, participants, and registry in their written submissions to 12 pages, which is what we did in Al Rahman. If you, for some reason, want to add to that limit, you must apply for permission and explain why. As far as further submissions are concerned, we're going to hold 2 more status conferences. We would prefer that unless there is something that needs urgent resolution, submissions are made at those status conferences so that they can, if at all possible, be dealt with orally. But as I say, if there's something really urgent, then of course you can file a submission. Right, it was brought to my attention next, before I deal with the rulings, that I wasn't altogether clear this morning about the question of protocols to be used. So I'm going to now read out what we say about protocols. As a general rule, the Chamber will use the protocols that are already in place in the Chamber's manual. As I've already indicated, Chambers will allow witness preparation. The registry is instructed to file in the record the witness preparation protocol, the familiarization protocols as used in the Al Rahman case, which mirror those in the model conduct of proceedings. The registry is to liaise with the parties and participants and report back to the Chamber on the proposed use of dual status, vulnerability and redactions by the 15th of June of this year. If changes are foreseeable to the e-court protocol, the registry is to liaise with the parties and report back to the Chamber with a proposal, particularly as regards submission of evidence during the course of the trial by the 15th of June. Right, I hope that yes, sorry, and I forgot to say that the cut-off, no, I was about to say that actually, but anyhow, the cut-off date for any applications from the victims to participate in the proceedings is the end of the prosecution's presentation of evidence, and we will follow the ABC participation approach. Right. As far as the fitness, the assessment of the fitness of the accused to stand trial, what we decided to do is that in the light of the short discussion, it would be preferable if the parties could liaise together and prepare a proposed joint letter of instruction. We were going to do it ourselves, but then we thought that you might then want to object, so it's probably simpler if the two of you can come to an agreement. We would like that, please, by Friday of next week, which is the... actually, no, I think we said a week today. What's a week today? 3rd of June. Yeah.
Wednesday.
Yeah, sorry, my fault. Not Friday. Wednesday, the 3rd of June. And registry, we would be grateful, please, if you could contact the experts immediately to check on their availability and let us know by the end of the week. That's the 3 experts who saw him before. Right, as regards, first of all, then to the decisions we've come to, the start of trial, we are prepared to accede to the prosecution's application of the 30th of November as the start of trial. The trial will run on a daily basis until the judicial recess, or thereabouts. We have to wait for the report on the accused's fitness, and they will specifically be asked to, if they find him fit to stand trial, about the proposed sitting. The Chamber would obviously like to sit, subject to witness problems, 5 days a week. But we note the recommendations that were made for the confirmation hearing, and so it may well be that we'll have to adjust it. If we have to have a day for the accused not to be in court each week, that doesn't necessarily mean it won't be a sitting day, because we can use that day to deal with any administrative matters or any legal arguments that are due to take place, subject, of course, to the accused waiving his right to be present. So effectively, at the moment, as I say, subject to what reports we get, it should be taken by all participants in the registry that we will be sitting continuously until the recess at Christmas. We very much also urge the registry to make the necessary arrangements so that for the opening statements at the end of November, there can be interpretation, even if there isn't a sufficient pool of interpreters for witnesses. I think it's important that opening statements can be understood by those in the Philippines. Right, so the deadlines for the prosecution in the lead-up to trial. The prosecution provisional list of witnesses and evidence by the 29th of June. Its trial brief, final list of witnesses, and list of evidence relied upon in the trial, 31st of August, which is 3 months before the trial. And the same deadline, that is the 31st of August, applies if you wish to add new incidents. Plus the list of experts, and appreciating the difficulty sometimes in getting experts to provide reports. We would like as many reports as are available, and if a report isn't available, then at least a summary of what it is expected that the expert will be saying in his report. Any evidence disclosed or to be added to the list of evidence after that date is strongly discouraged and will be subject to the Chamber's authorization, good cause to be shown, with a full explanation for the reason for the delay. Simply a reminder that disclosure of exculpatory evidence and Rule 77 should be done on a rolling basis. After our discussion this morning, review your evidence to make sure that we avoid having repetitive, irrelevant, or over voluminous evidence. And as already discussed, the witnesses interviewed under Rule 55, the schedules that we discussed and which are familiar to you from the Al-Rahman case. As far as pretrial motions are concerned, if there is any issue that needs resolution before the start of the proceedings, pursuant to Rule 134(1) and 2, again, cut-off date 31st of August. I'll give you the dates of the status conferences in a moment, but we will deal with them all, I hope, then. And of course, obviously, if it's urgent, that's a different matter, and it should be filed as soon as possible. The dates for the next status conferences between now and the summer recess are the 23rd of June and the 14th of July. As indicated this morning, the defence's indication of issues and defense to be provided by the 30th of October. The legal representative of the victims' trial brief, 28th of September. As far as agreed facts are concerned, we're not going to set a deadline, but we will review the position at each of these status conferences. We echo or repeat our hope that you can reach a substantial number of agreed facts. Having considered Ms. Masida's representations, the LRV can receive notification of what facts have been agreed and can make submissions on this, which the Chamber will consider. As far as the conduct of proceedings is concerned, I've mentioned some matters. There will be other matters dealt with in that. Effectively, it will be it's intended that it will very much be the same model as that in the Al Rahman case, which also models the Model 1 in the Chamber's manual. But if anybody wants to suggest amendments to it, they must do so by Friday, the 5th of June, so in other words, next Friday. I mentioned this morning that we were thinking of trying to find a balance between the submission and admission process. But I'm reminded I think that the conduct of proceedings and indeed the Chamber's manual states that where there are documents which the Chamber or the parties consider are important ones, it can be, whether or not it will be admitted, can be dealt with at the time that the document is tendered. But I really do emphasize we don't expect to be drowned in documents. So those are the rulings, unless anybody thinks I've missed anything out that I said I'd give a ruling on. And unless there are any other matters, that concludes to the Status Conference. Nobody got any other matters? No, right. Yes, thank you all very much.
All rise. We will agree.